Hey guys, it's Gary, and I'm back with a legal tip today on failed contingency. So, a lot of the contracts you see in the market will have a contingency on financing, contingency on appraisal, contingency on maybe the sell and close of a house. Lots of contingencies out there that could be in a contract. But the question is, what happens when the contract contingency fails? Is that a default? If it's a default, or not a default, who's entitled to the earnest money? What happens in this situation? Well, a contingency is basically a condition precedent that has to occur before the borrower, or the buyer in this situation, is required to perform. So if the buyer, for example, has a contract that is contingent on financing and their ability to get the loan, in order for the buyer to be required to perform, and the performance meaning completing the completing the transaction, the borrower has to be able to get that loan. So if the buyer is unable to get the financing and get the loan, then they're unable to get the contingency completed. At that point, the condition precedent, the condition in order to make them perform, hasn't occurred, and they are relieved of their duty essentially to perform. So it is not a default, it's just a failure through contingency. What that means in most situations, depending on what state you're listening in, but in South Carolina, if you default, you may be liable for damages to a seller, such as losing earnest money, specific performance, and other damages. But when a contingency fails, there is no default. So the earnest money would go back to the buyer because the contingency failed. Now, the contract may state different when your jurisdiction, or you may have contracted it different. So, for instance, you may have made the earnest money hard, or there may be a time frame in which they had to perform, or they lose the earnest money goes hard. So there's other factors, but I'm talking in your general sense. If you're using the CCRA contract or the state contract, the general sense of those contracts, you have a contingency, the contingency fails, it is not a default, earnest money would go back to the buyer in those situations. Remember the earnest money rules, you still got to have that release signed, you still got to get that court order, that mediation in order to release money if your agents are holding money. All right. Also, don't forget this week to check out our podcast. I think it's a very good podcast. I went through Realtor.com, Zillow, Redfin, the mortgage company, going all through these different groups and listened to or read what they're stating as their predictions for 2022 in terms of the real estate market. Will the market go up? Will it go down? Will prices go up, down? How will our inventory look? And things of that nature. So if you haven't had a chance to listen to this week's podcast, I highly recommend it. It's up there in that corner right there and down below. So hope everybody has a great weekend, and we'll see you here next week. Take care.